Hi everyone and welcome to today's Sessions with Sarah. For those of you who have not joined us in one of these sessions before or don't know who I am, I'm Sarah Coombs. I'm a solicitor and partner here at TBA Law and I work primarily in our area of family law. This is quite a complex issue and in their sessions we just try and deal with some of the more common questions we get. You are more than welcome to send us a message or a request for us to cover a particular topic. But today's topic is what to do when your ex isn't following a custody arrangement. This is a complex area. There can be reasons why people don't follow custody arrangements and it's important to be aware of those. It's also important to be level-headed and reasonable when it comes to these sort of things. Custody arrangements deal with children. There are lots of reasons that there may need to be a minor amendment to a custody arrangement. However, if there's a more serious breach, that's when we need to potentially look at legal action. So the first thing to know about when breaching a parenting arrangement or a custody agreement is to know how it's embodied. So is there something in writing in place? And if so, is it a parenting plan or a consent order or another order of the court? So if there's a parenting plan in place, this is an agreement the parties come to by consent. They both sign it. It is legally acknowledged but not legally enforceable. That means the courts can't enforce that parenting plan itself. It's merely acknowledged by the court as what the arrangement was, but like I said, the court can't actually force a party to adhere to this agreement. Therefore, they are limited in their use. Whereas if there's a consent order or a court order in place, the court does have the power to force parties to abide by these. However, that's very much a last resort. So your ex has breached the custody agreement that you have. What's your first step? This depends on the severity of the breach. There are obviously breaches ranging from, my husband was meant to drop the children back at 4 o'clock, he dropped them back at 5 o'clock, I want this fixed. And then there's, my husband was meant to drop the child back last week, he hasn't dropped the child back, what do I do? So there are two very different levels of breaches and two very different levels of approach. Where possible, it's always best for the parties to speak directly and see if they can sort it out. This is best from both the child's point of view in terms of making sure that relationship is amicable and they're not caught in the middle of anything, but also in terms of saving on legal fees. If parties can work it out themselves, all the better for it. Obviously, this is not always appropriate or the best case, particularly if there's family violence or if it's a serious breach of the orders. The second approach we recommend parties take is to mediate potentially, and again, this depends on the severity of the breach and the urgency of the breach as well. It's often a court requirement, and what courts will do is refer parties back to mediation prior to dealing with an issue, particularly if it is like one of those issues that, I only have the kids till 4 o'clock on Mother's Day, I want them all overnight on Mother's Day or something like that. It's a relatively minor issue in comparison to things, so it's really important that if parties can, they mediate, because this is a very low cost resolution. It can be done through Relationships Australia at a cost of about $80 to each party. Parties are also able to mediate using a barrister and solicitors if they wish, but again, that's a little bit more costly to do that, but that's well within parties' powers to do that. Another approach you can take is to engage a solicitor to write some letters back and forth. This may be preferable before going to court, and in fact it is when you, particularly if you need to put the other party on notice that you might be applying to court. Letters between solicitors though can add up very fast and may not have the desired effect. The most serious approach that can be taken is a contravention order, or seeking a contravention order of the court. This is when you apply to the court to say the court, something was not dealt with. Now, like I said, the court probably doesn't want to deal or won't deal with urgently something as simple as changing times on Mother's Day, or another party dropping the children back an hour late. What they will deal with is if a child isn't returned to someone's care, if a child is exposed to risk or something along those lines. They can be costly to obtain. They are urgent court applications that need to be done. And we do recommend people get specialist legal advice. One potential avenue in a contravention order is what's called a recovery order. A recovery order is an order to have a child returned to the custody of one of the other parents. This can be done with the assistance of the Australian Federal Police. This is a last resort option. There can also be urgent court orders if you're worried that the other party will leave the country with the child and may not return. Like I said, court orders are very serious action, and contravention orders are not very easy justification to do so, we highly recommend that parties seek independent legal advice before filing for those. And they often need to be filed as urgent matters. But like I said, if it's a minor issue, the court's just going to refer parties back to mediation anyway, so it's very important that parties can engage in that family dispute resolution first. The final thing to note about contravening parenting orders or a parenting arrangement is a reasonable excuse. We've seen a lot of this during COVID, where parenting orders were breached purely because of COVID, i.e. The children had to isolate with one parent, they simply weren't allowed to leave the house, or parties had to drop children back late, or arrangements needed to happen. So it is possible that you might think an order's been contravened, but there's a reasonable reason why that has, and therefore we recommend people make sure that logic prevails. Like I said, COVID had showed us a myriad of different issues that can arise because of these parenting contraventions. And so the court actually dealt with it in a special COVID-19 list if that is the issue. But for the most part, serious matters need to be filed urgently in the court. So that's a very brief overview of what to do if your partner or a former partner breaches a parenting plan or consent order. We do recommend you get specialist legal advice. And if you have any queries, you can contact our office. Otherwise, thank you for tuning in, and you're welcome to contact our office with any questions or if you have any requests for the Facebook Lives in the future. Thank you.